Welcome to Beyond the Handbook, where we accept that no one has actually read page 47 of the Employee Handbook. I'm Chris Scott, and today we're going to be talking about something every employer has, but almost no one uses well, the disciplinary policies of the handbook, and how to use them both as a sword and a shield for your business. This podcast is brought to you by Thomas & Hafer, LLP. It is for informational and educational purposes only, and isn't legal advice. Listening does not create an attorney-client relationship. Laws vary by state, so please consult your own local counsel for advice regarding your specific situation. Now, every employer has some kind of disciplinary policy. For some, it's a few throwaway lines about corrective action. For others, it's a large, multi-page flowchart that looks like it could come with a board game. Used well, an employee disciplinary policy can protect you. That's the shield part of it. Used thoughtfully, it gives you room to act decisively when you need to, and that's the sword. Used badly, it creates the expectation that you never meant to create, traps you in a step-by-step ritual, and makes your own handbook Exhibit A for the other side during trial. So today we're going to break down this into 3 parts. Number 1, how discipline works as a shield. Number 2, how to keep it flexible enough to be a sword. And one of my own personal pet peeves, number 3, the probationary period, and how quietly it undermines everything that you thought you were doing and you thought you were doing well. All right, let's get into it. Segment 1, discipline as a shield. Let's start on this side. A good disciplinary policy protects you at the exact moments that you care about the most. Number 1, when you terminate someone and they file for unemployment. Number 2, when they file a discrimination or retaliation charge. And 3, when they've had workers' compensation claim and now performance is an issue. The shield works when you can show 3 basic items. Number 1, the employee knew the rule. Number 2, the rule was enforced consistently. And number 3, you documented the conversation that there was a problem. That's it. The legal bar is not perfection, it's credibility. Do you know what juries and agencies really dislike? When the rules seem to apply differently based upon who the person is, or who their supervisor is, or what mood management was in that week. That's when this gets undermined the most, in front of juries and in front of administrative law judges. And yes, that does mean that once in a while you have to discipline a star performer. I know that hurts. Some of you may not want to hear that. I'm sorry. But every time you look the other way for a favorite employee, you're writing the closing argument for the employee you discipline later and how they feel they can get around the policy. Segment 2, discipline as a sword. Let us flip it back and talk about the sword, the part where you actually have to take action. A disciplinary policy is not just a shield in litigation. It's also the tool that lets you say with a straight face and a clean record, we addressed this, we warned you, the pattern continued, and now we're done. For that to work, your policy needs one magic ingredient, discretion. If your policy says something like, we use a 4-step progressive disciplinary policy, verbal, written, final, termination, you've just handcuffed yourself. Because now employees and their attorneys will read that and say, did this person get all 4 steps? Where's that verbal? Where is the written? Where's the final? And where is the separation? You want the language that gives you structure without promising a rigid sequence. Something along the lines of, the company may use progressive discipline where appropriate, but reserves the right to skip steps or proceed directly to termination based upon the severity of the conduct, prior records, and current business needs. That one sentence is huge. It says we have a framework, but we're not obligated to walk slowly towards the cliff while someone sets fire to our business. Discipline shouldn't be a ritual that you're stuck completing. It should be a tool for managing behavior and risk. Segment 3, the discipline disasters. Let's hit discipline disasters that I see over and over again, even with good employers. Number 1, pretending verbal warnings actually exist without paper. A truly undocumented verbal warning is just a conversation that you hope you remember. I'm not saying you have to give every employee a 3-page memo, but at least send yourself an email or jot a quick note in the HR system. For example, talked with John on March 10th about repeated late arrivals, reminded him of attendance expectations. That's it. You don't need to do anything further. Then, when you're on the stand 18 months later and someone asks, well, what did you do before termination? You're not saying, I don't remember. I think I had a conversation with him. We talked sometime around the Super Bowl. That's in your email. That's documented, even if it didn't provide a document to the employee. If it's not written down, assume that it didn't happen. Another problem, talking around the issue. The corrective meeting is not the time for interpretive dance. If the issue is performance, say performance. If the issue is attendance, say attendance. If it's conduct, ditto. Not, we'd like you to be more of a team player. That means nothing. It sounds like a line from a corporate retreat pamphlet. It's buzzwords. Be specific. Tell the individual, you rolled your eyes, you walked out of a meeting, your supervisor was still talking. That's disrespectful. It can't happen again. Here's your verbal warning. It's awkward for about 4 seconds. It's going to be awkward. But then it's clear. Ambiguity is a breeding ground for claims. I didn't know what they wanted. They never told me directly. Those things are fodder for a jury and for an administrative law judge to get the person into a position where they are receiving benefits. The next problem, weaponizing attitude. My personal favorite and the thing that drives me crazy, we're disciplining you for a bad attitude. Bad attitude is not a legal standard. It's a vibe. When discipline is based on attitude, it's very easy for employees to connect it to protected activity. I complained about my harassment and suddenly they didn't like my attitude. I asked for light duty for a problem that I was having with my leg, and now I'm not a team player. Instead, as an HR individual, you need to focus on observable conduct. You refused to follow a direct instruction. You raised your voice with your boss and used profanity while in the presence of a customer. You responded to emails days late and missed several deadlines here, here, and here. You can still mention that there's a tone or a manner or a problem, but you need to tie it to something concrete. You can't discipline somebody for being annoying, but you can discipline them for what they do. And if you must use the word attitude, at least make sure it's attached to a specific behavior, not just that they were sighing loud enough to rattle the windows. Segment 4. My personal pet peeve, the probationary period. This is something that makes a lot of employment lawyers twitch. Their eye gets a little bit wonky, the lip curls up. The probationary period. 95% of the employee handbooks that I've opened up have it. All new employees will serve a 90-day probationary period. Sounds pretty professional, sounds structured, but it creates a confusion that is pretty much confusing on every single level. The employees think they're safe during probation, and they think they're safe after probation. From the employee's perspective, probationary period sounds like for 90 days, I got to toe the line, and after that, I have earned my job security. And in that will world, that is the wrong message to send to any employee. You didn't mean to promise anything, but now you've set up the storyline of, hey, I passed probation, I must be doing fine, and then I got fired, so something else must be going on. Maybe discrimination, maybe retaliation. A savvy plaintiff's lawyer will happily ask, why call it a probationary period if it doesn't mean anything? The second problem with a probationary period is that employers and HR think that it's a no-rules window. On the employer side, the probationary period often gets treated like free termination zone. Well, they're still in probation. We can just cut them loose. No documentation, no drama, no worries about accommodation, injury concerns, anything like that. That's not how it works. That's not how any of this works. You're still subject to the same laws, discrimination, retaliation, whistleblower protections, workers' comp, etc., etc., etc. Firing someone 2 weeks after they report harassment or file a claim, even during that 90-day probationary period, is going to look bad. The fact that they're within their 90 days doesn't magically fix any of it. Probationary periods also undercut at-will language. Most handbooks will say some version of all employment is at will and may be terminated at any time with or without cause or notice. That usually comes a few pages after a successful completion of a 90-day probationary period in the same handbook, sometimes under the same section. What happens after that 90-day period? Is it a level up? Does it unlock premium features to that employee? There's an implication there that something changes at day 91. And if the handbook can't decide whether employees are at will or post-probation secure, don't be surprised when a hearing officer or a jury reads it in the worst possible way. So now employees think they're protected after probation. Employers think they're untouchable during probation. The law says neither one of those is actually correct, and treat everyone exactly the same during the probationary period and after. What does a probationary period actually mean? Well, if you must have a probationary period, many organizations want it for onboarding. It needs to be clearly defined as an introductory evaluation period, not a mini tenure track. Maybe say something like the first 90 days of employment are an introductory period intended to evaluate performance, attendance, and overall fit. Successful completion of this period does not guarantee continued employment or change the at-will nature of the relationship. Treat it that way. Use it to give it honest feedback. Address obvious misfits. Address and decide whether the person needs to stay in that role. Don't treat probationary period employees as though you have no obligations to them. Don't imply that once they pass probation, you'll owe them 17 steps of progressive discipline before you can act. Here's a rule of thumb. Probationary periods are fine as a management tool, dangerous as a promise, and absolutely useless as a force field. If your probationary language sounds like it's granting job security or giving you a 90-day do-what-you-want window, that section needs to, go beyond the handbook and into the garbage can. For this episode's Tool of the Week, I've put together a one-page corrective action script and documentation template. It walks you through the opening of a meeting without turning it into a trial, stating the concern in plain language, referencing the policy or expectation, outlining what improvement looks like, and documenting the conversation in a way that actually helps you later. There is a short section with a sample language to clean up probationary clauses so it can work as an evaluation period without accidentally promising job security. Thank you for listening. Here's the big picture. Use your disciplinary policy as a shield to show clear expectations, consistent informant, and honest documentation. Use it as a sword with enough flexibility to act when behavior or misconduct really warrants it. And make sure your probationary period isn't quietly telling a story that your lawyers never agreed to. If you'd like a copy of our corrective action script and documentation template, along with a sample probationary period language, reach out to me at Thomas & Hafer. We'll be happy to send it over. My email address is cscott@tthlaw.com. I'm Chris Scott. Thank you for listening. This is Beyond the Handbook, where policy ends and the real work begins.